So structural defects, we're talking about the major components of the building, right? The foundation, the supporting beams, the roof, the things that are holding the building up. And then we have a 1-year warranty, and this is now for the individual units. So for the plumbing, sanitary, mechanical, electrical installations, if there's a defect, then they have to repair it within a year. Now, when does the clock start running on these warranties? It starts running from the date of the completion certificate. So not handover, from the date of the completion certificate. And those of us who deal with these type of off-plan properties, we know that handover sometimes happens well after that completion certificate date, or excuse me, even well after even the 1 year is over, correct? So if the developer isn't on their own offering an additional warranty in addition to what they have to give you per the law, then you're a little bit out of luck there. Is a defect that is obvious from a general inspection, even a walkthrough of the property. Let's say it's handover time, you're walking through, if the floor is tilting, we know there's a foundation problem, right? Or if we see a huge crack, I'm not talking about these superficial cracks that Doug talked about earlier, but a huge crack in the wall, we know there's a structural issue of some sort. Something that's obvious and can be discovered immediately. And then we have latent defects. Now these are hidden defects. These are defects that we need an expert like Doug to come out with his equipment, go behind the walls, under the floors, etc. to discover. This 10-year, so the 10-year limitation on filing a claim starts upon the discovery of the defect. And if it's a latent defect, and let's say now the 10 years has already passed, there's an additional 3 years if it was a hidden defect that required an expert to discover. Or if the building happens to crumble and then you discover that there was a defect that way, then you have 3 years from that date to file your claim. We have to move on with litigation. So we have 2 jurisdictions here in Dubai for litigation or dispute resolution. We've got Dubai courts and we've got arbitration. And then we'll talk about arbitration in a minute here. In Dubai courts, which most of the developer SPAs have as the jurisdiction, as well as Form F, you have to file within Dubai court. Now, how does Dubai courts work? Here in the UAE, we're in a civil law jurisdiction. Civil law jurisdiction means that the judges do not have to rely on the decisions of other judges in cases with similar facts. What they do rely on is what the civil code or the laws state, and they can come up with their own interpretations of the law. So therefore, it happens very often where we have 2 separate cases where the facts are pretty much the same, but 2 different judges will rule 2 different ways. One will be for the buyer, one will be for the seller. So obviously we want to stay out of court, right? That's the whole goal. We don't even want to be there in the first place. So how do we do that? So Eda talked a little bit about the inspection contingencies. So we need to put these inspection contingency clauses into our, well, you call them MOUs, but they should now be called addendum to Form F, since MOUs are considered illegitimate by RERA since we have Form F. So you need to put them in your addendum.